Welcome to Module 1, Lesson 3 of Introduction to eDiscovery. So in this module, we introduce eDiscovery proper. So what is discovery? But before we go to that, let us find out what is discovery. When there is a legal dispute, parties involved in the dispute can request for evidence which is in the possession of the other party, that is the opposing party, before the proper court proceedings, just to get a feel of the quality of evidence in the other's possession. That evidence could influence a decision whether to go ahead with the case or to drop out and probably settle out of court. Either party can make a request for such evidence, whether the defendant or the plaintiff being the party who takes the other party to court, as in who initiates the lawsuit. And by law, if any party requests for such documents as evidence, the other party is obliged to provide. That is, it is compulsory for them to provide it, except if they have a very good reason why they cannot. So this is what is known as discovery, which has been in existence for at least prior to electronic discovery. So the discovery could just be defined as the process where opposing parties in litigation review the other's evidence, that's evidence in the other's possession, before going to court in order to assess the quality of the evidence. Judge Shira A. Scheindlin, I hope I pronounced that correctly, had said that eDiscovery used to be considered as a subset of all discovery, but now there is no other discovery. That does not mean that only eDiscovery is in existence, but it's just to show you how important eDiscovery has become, particularly in modern times. And Judge Shira Scheindlin, we will soon hear about her in the case of Zubulek versus UBS Warburg. She was the judge in that case, and also she was one of the pioneering judges to make suggestions about how to develop eDiscovery. So what is eDiscovery? eDiscovery is essentially the electronic version of discovery, whereby the evidence is ESI, electronic evidence, digital evidence. It's basically the same thing as discovery, only this time is the electronic version of it. So it is the process where the opposing parties in litigation review ESI in the other's possession, that's the opposing party's possession, to assess the quality before proper full court proceedings to determine whether or not to go ahead with the case. So essentially, eDiscovery just uses traditional processes of discovery on digital evidence, and also the digital evidence used for eDiscovery has to be collected, analyzed, stored, and presented in a legally acceptable manner for it to be admissible in court. So that is to say, the digital evidence has to be forensically sound. Looking at it this way, it looks like there is obviously a similarity between digital forensics and eDiscovery, because even based on this, we can see that it is also a convergence point between information technology and the law. There are tools that are used for digital forensics which are also used for eDiscovery. There is a correlation between eDiscovery and digital forensics. That said, what is the difference between eDiscovery and digital forensics? Well, for eDiscovery, the evidence requested is essentially known, so to speak, is evidence that is specific to a case that has been brought forth. So it's more straight to the point. But in the case of digital forensics, it's likely that you might not know exactly what you are looking for. So a full investigation will be required. So that might involve a wider range. You don't have a specific target evidence, target ESI. So you might have to go through all the ESI before you get to know what may have transpired or what exactly you are looking for. So that's it. Of course, that means there's obviously more volume of data required in digital forensics as more volume of ESI based on what we have already said. Even though for eDiscovery it might be a very huge volume of data, a lot of terabytes, but even if you're having 100 terabytes for eDiscovery, if it comes to digital forensics, you might be looking at maybe 1,000 times that amount because the volume of data required for eDiscovery is already specific. But for digital forensics, you are trying to find out what has transpired. So you'll be trying to go through all possible ESI to try and get to the bottom of what may have happened. While in discovery, for eDiscovery, you already know what the issue is, and then you need more specialization and there's more in-depth investigation in terms of digital forensics as opposed to eDiscovery. The specialization is not necessarily, that doesn't mean that there's no specialization required anyway, but the is less than would be required when it's a digital forensics investigation that would be for eDiscovery. That brings us to the close of the third lesson. See you in the next lesson.